The next speaker is Olivia Struiven. Olivia has been working for the International Criminal Court since December 2003. She was amongst the first staff members of the Office of the Prosecutor, and since January 2005 she's working as a trial lawyer on the Lubanga case, but she also worked on the Kenya situation, the Bosco and Taganda case, and more recently the Yekatom case in the Central African Republic. Olivia, you have the floor.
Thank you very much. First of all, I think I would like to thank everyone here for inviting us. I think the ICC has had a few negative developments recently, and I think it's really important that we keep on thinking and talking about international justice in general. So I'm very grateful that we can be here today. So I have 20 minutes to talk about the Office of the Prosecutor. That is an impossible task. I can talk for like 3 weeks about the Office of the Prosecutor, especially since I've been a member of the Office of the Prosecutor since the very beginning. So I've seen the office evolve from a team of 5-10 individuals up to a team of 200, 250 individuals. So I've reduced my presentation to the basics, I think, but I may develop as I always do. So the Office of the Prosecutor, in a very, very simplistic scheme, our prosecutor is called, as you all probably know, Fatou Bensouda. She used to be the deputy prosecutor under the previous prosecutor. And we have, in fact, 3 main divisions, which you can see below, is the prosecution division. These are the prosecutors, the people that will present the evidence in the courtroom. As a member of the prosecution division, you also sometimes assist interviews in the field, in the countries we're investigating, especially when it concerns witnesses that we believe will come to testify. But in essence, it's the investigators who are part of the investigation division. They are the ones who normally, from the beginning onwards, will go to the field, will collect the evidence in the field. They will discuss evidence collection with telephone companies. They will go and meet witnesses. They will ask intermediaries for leads to find other witnesses, etc. So they're the typical, your classical investigator. They're sitting in the investigation division, and then the prosecutors who are sitting in the prosecution division will join the investigators later in the case to also, of course, test the credibility and the appearances of certain prospective witnesses. The third division we have is the jurisdiction, complementarity, and cooperation division. These are our diplomats, as we call them, and most of them have a diplomatic background as well. So they're internal people and internal staff members, and they will constantly negotiate with member states, but also with NGOs, UN. They will constantly negotiate and try to get as much cooperation as possible. And this will be a bit the red thread throughout my presentation. Cooperation is key. I mean, we've come to realize, and it's, of course, we've realized this from the beginning, but what I've realized after 15 years is that it's all about cooperation. And I think in the early days, we still thought we could do a lot ourselves, and we were independent, and we had to go to the field on our own, etc., etc. I think by now, especially with the development in the types of evidence we're looking at, I'll come back to that later, cooperation is pretty much the only way forward, I think, for international justice. So the cooperation division is quite an important division. Now, how do we get a case? There's basically 3 ways of getting a case into the ICC, and I'll elaborate on that again, as well as talking about cooperation. The first one is the state referral, and this was a remark about the African cases. We have indeed a lot of African cases, but it's also because a lot of African countries have asked us to investigate and prosecute their cases. So the DRC has asked us to intervene, the Central African Republic has asked us to intervene, Uganda, the Côte d'Ivoire, and Mali all have asked us to intervene in their country because the crimes were committed either in a region that was not accessible or difficult to access, or because the perpetrators, the alleged perpetrators, would have been too controversial to prosecute locally, or because the systems were just not in place yet, or not after the conflict, they didn't have time yet to redevelop their systems. State referrals are the easiest to prosecute by far. Why? Because literally when our investigators go to the field, so they literally take a plane, they arrive in a country, they notify the state authorities, they get an invitation letter, everything goes smooth, they get into the airport, they can go through the border, I don't know how you say this officially. So there's no issue, they can go through, no one will check their bags. The same thing when they return with evidence, no one will stop them, no one will interfere with the collection of evidence. They will not necessarily, put checks in place, they will not be arrested at the border, etc., etc. It's a much easier way to investigate these cases. In most of these countries, we actually also get really good cooperation from the states. So we get documents that we want, we get military documents, we get intelligence documents, we get records when we need, I'm looking at a national prosecutor, when we need national prosecutors to get us information that is subject to a state's court, a national court's decision, they get that for us. So that's by far the easiest way to investigate and therefore also prosecute. The second way we get things, cases, cases, is by the UN Security Council referrals. So we got that in Darfur and in Libya. The gigantic problem there is that if for example, Darfur, if the president of Darfur does not want to cooperate with us, we cannot enter the country, so all of our evidence will literally have to be collected in countries next to the country, for example, Chad, which is possible. It's not impossible, but it means that you're much further away from your actual evidence. Your phone records will not be in Chad, they will be in the country itself. Your witnesses will have to be contacted outside of the country. So it becomes already much more difficult if you can't go to the mass graves, you can't access you can't, for example, if you're prosecuting or investigating a particular crime committed in a particular village, at some point you want to go to that village. You want to talk to the inhabitants of that village who are the most likely to get information or to give you information about the village. But you also want to look around, you also want to see how the village is organized, whether the stories of your witnesses match the physical location, whether there's mass graves, whether there is anything else that shows destruction of a mosque, the destruction of a house. You can only do that if you're in the country. So if you can get into the country, it becomes much, much more difficult. And then the proprio motu powers, so that's an invention, or that's a novelty, and there was a lot of discussion in the Rome conference, whether or not to give the prosecutor true independent proprio motu powers. They ended up, the final draft, of course, foresaw those proprio motu powers. What it means is that we get literally from anyone and anywhere, we can get complaints. So we can get little files, literally, or letters or emails or of people all over the world who can send us a complaint of a crime they believe happened to them or their community or anyone they represent. So if I tomorrow, it's a bad example, but if I tomorrow live in a village somewhere very remote, my village is under attack, I can in theory send a document to the ICC about what happened. Now, what happens then in practice is that we get all these complaints. There is a very clear organizational system in place. So we group all the countries together, we group all the type of crimes together, we group all the locations, the places, and then from there we can start proprio motu investigations. Often it will be the situations that are boosted by NGOs that are behind a certain crime scene or that are supporting the victims of a certain crime scene, etc. It's not been a great success, our proprio motu, so far. And one of the main reasons, of course, is that we're having exactly the same problem as the one that we have with the UN Security Council, which is that if the country is not behind us prosecuting a situation in the country, it will become much more difficult for us to actually access evidence, to access witnesses, to access state documents, etc. this was much for longer than I was supposed to talk about this. But so once we've decided, as I said, once we've decided to do a case, we go into a full investigation, and then at some point we decide, and I'll see if I have this on the slide. Yeah. So once we have reasonable grounds that a person committed a crime under the jurisdiction, we issue an arrest warrant application. We draft an arrest warrant application. We ask the judges to look at our file. They come back to us, and this has happened last week. So we are quite happy about that because it's in my case. So the chamber then confirms that there is indeed reasonable grounds to arrest someone. They issue an arrest warrant. The arrest warrant goes through very helpful international cooperation, state cooperation. So our people then start looking for states who are willing to, or Mark's people, or are looking for possibilities to arrest the individuals, and once the people are arrested, they come to The Hague. This is what happened last week, as I said. And then we go into a two-phase process. We go into a confirmation hearing, where they confirm the charges, and then we go into a trial. This is technical, it may not necessarily be that in. Now, in terms of the guiding principles, I'll go briefly. The first one is, of course, independence. We do not get, and I can confirm, we do not seek instructions from anyone. The reality, though, is that, and sometimes people are confused about this, and they say that we're a political court and that we're politicized and that we only do what we do. So we're independent and we look at crimes objectively, absolutely guaranteed. But what is true is that there is very practical factors that make us investigate certain cases rather than others. If we don't have access to evidence in a certain case, we may want to investigate the case, but we can't investigate the case because we can investigate the case, but without the necessary elements of proof or the elements of evidence, we will not prosecute the case. So there's a lot of cases that we're investigating, but at the end of the day, we have a limited amount of people, a limited amount of resources, and at the end of the day, the cases that we will prosecute will be cases in which we believe we have enough evidence. And we need to have enough evidence before we can actually make that decision. So there is cases that we would like to prosecute, but we just don't get enough evidence on those cases. So it's true, and some people then think, yeah, but that means that you're political. I strongly believe it's not that we're political. It's just that we will, because we don't actually get political influence in the selection of our cases. Most of the case selection is done on very practical considerations rather than, it's not that we get phone calls saying, could you look into this case rather than that case? That's absolutely not what happens. But what does happen is that we evaluate our chances of getting information and then the practical considerations. And then we evaluate the strength of our evidence, as any prosecutor does, I hope. You evaluate, once you collect your evidence, you evaluate whether it will survive a judge's assessment. But that's, yeah, objectivity. So this is outdated, but this is a little bit the idea, and you see the Africa comment is still valid. These are the cases we're investigating and where we have preliminary examinations. As you can see, most of it is in Africa. The blue countries are the ones that are member states. But so this is a visual. In terms of the cases, maybe just to give you an idea, the difficulties and the challenges and everything at the same time. So as we've had, by now we've had several cases. We still have a lot of investigations going on in different situations. To pick a few, just because I worked on them and I know them better than the others. So our very first case was a child soldiers case. In terms of background, as you may know, and this is for our diplomats, is an important, I always say this during conferences because I think it's important. So the DRC started using child soldiers simultaneously with the import of Kalashnikovs, basically. The reason is that children can only be useful in a war as soon as they can manipulate automatic guns. If you give a child of 9 years old a machete, the child will do nothing with that machete, simply because if a child hits you with a machete, there will be absolutely no consequence. So what you see happening, and it's a very sad development, is that in most of these countries, when the flow of weapon deliveries started to boost from different countries, because they don't produce their own weapons, obviously, Together with that boost, you see younger and younger children getting involved in the conflict, because you can, a child with a Kalashnikov, despite the fact that the child cannot necessarily use the Kalashnikov that easily, because your backlash from any gun is quite heavy, but the fact that he has it in his hands is enough for the victim to do whatever the child asks to be done, just because the victim will never take the risk, or the victim will not dare to trust that the child will not be able to actually use the gun properly. So you see this in the Congo wars, because there's been several Congo wars. We see this line between weapon deliveries and the increase of child soldiers. The child soldier cases have been really difficult for a variety of reasons. One of them obviously is age. I always say this: when you're fleeing for your life in a conflict situation, if you have an identity card, which most of the children in this region, in Ituri, don't have, but even if you would have an identity card, it would not be the first thing to take with you when you're leaving your house or place, just so that you could later on prove your age. In the DRC, the first proof we got was actually the election cards. So they started issuing, in the DRC, they started issuing election cards at some point, and those election cards, which were, I think, even created by a Belgian company, were the first ones to identify the date of birth properly. But so date of birth has been a problem. Also, for example, we have these wrists analysis, we have teeth analysis that we can do, but the scales for these analyses are based on Caucasian white individuals, or at best African American individuals. But so we don't have necessarily the science behind each of these populations in these African countries. What else has been difficult with the child soldiers cases is that there's a very important loyalty between the child and the commander. So once the child gets into an army, and often these children went into voluntarily, there's no such thing as voluntarily joining an army until you're at the age of being capable of joining voluntarily. And that's a good thing. So legally also there is no voluntary recruitment, because you have to be capable of giving the consent. But so another problem we had is that a lot of these children, once they are in the army, the commander starts taking up the father figure. So, and now I'm going to speed up. I already speak quite fast. So anyway, so there is a lot of loyalty between the child and the commanders, and so it's difficult for the children to then testify against these commanders. So yeah, but yeah, it was a successful case at the end of the day. And what is interesting for us, and I think for everyone who is participating in international justice, we do hear a lot of references, interestingly enough, which is something we didn't necessarily expect. So in other cases, sometimes commanders are talking about the fact that they shouldn't recruit children, because otherwise they will get to the ICC. And we're like, at least we've, no, but at least there is some sort of a deterrent effect that we may not necessarily fully realize. But what we've seen in the subsequent conflicts in these regions is that they're still child soldiers for sure, but they're older. So the really visual 8, 9, 10-year-olds are not recruited anymore. They now focus on the 13, 14, 15-year-olds, which is still illegal, but at least it's not the very small ones. This is the Kenya case. We have several cases about post-election violence. The Kenya cases were about that. I'll go relatively quickly because I only have 3 minutes left, I guess, by now. The Uganda case, as you may know, the case is still ongoing. It's one of the more brutal cases we're prosecuting. So briefly, I don't know if you know about Kony, the Lord of Resistance Army, and Kony, who believes he's representing God on earth. And has a lot of followers. His typical way of, and there's a very good book by a Belgian journalist, Else Temmerman, who takes on a lot of these victims of the LRA. Again, a Belgian connection. But so what he used to do is that he would make his victims, so he would kidnap children out of the villages and then use them into his army to go around and commit the crimes in the next villages. And it was done in a relatively brutal way, in the sense that he would have them he would have an initiation process to install such a level of fear into his victims that they would, once they would have gone through the initiation process, they would not dare to leave or revolt against the... So what he would do typically is to ask one of the recruits to cut off the nose or the ears or the lips of other recruits or of family members. And once they would manage to do that, or even like there's even stories where they had to eat, so one brother would have to eat the other brother, or they would have to, together they would have to eat the mother and stuff like that. So, but it somehow it worked into a system where they would then, once they would have done that, no one would even dare to challenge his authority. We are prosecuting one of the higher commanders. He's at trial as we speak. The challenge there, or one of the remarks there, is that he himself was recruited like this. So it's this very strange situation where he himself was recruited as his name is Ongwen. He himself was recruited at the time innocently, because this conflict has been going on since 19 years. It's 20 years or so before they started the process. So the late 90s, I guess. 2 minutes left. So it's a situation where you're now prosecuting someone who originally had been a victim of the crime itself or the group itself. What else do I have? Oh yeah, challenges. So I'll very quickly go through these challenges. Yeah, I address this in part. Challenges is that we have, every time we do a new country, we have a new situation, we have to get the history right, we have to set up an office there, we have to get to know the background, cultural differences, etc. So, contrary to the Rwanda tribunal or the Yugoslavia tribunal, every single case we open is in a new country. And every country has different languages, every country has different cities, every country has different, so that makes it takes a while before we actually really get used to a new situation. The second challenge, of course, and that's the one I said from the beginning, is that we have no law enforcement agencies. This has already been addressed. So we depend 100% on state cooperation, and the better our state cooperation, the more we can actually do. I'll leave the clashes. Then the final thing, I think, on the future. Yeah, so one of the things we've realized is that I think with our evidence, we're going to go more and more into artificial intelligence. We've realized that there's and I think it's coming up everywhere. I'm not sure in how far the national jurisdictions are delving into that, but we're working more and more on artificial intelligence. There's a lot of information, for example, you can take from phones, from smartphones, especially locations. There is a whole new era of evidence analysis where people. For example, the UN is using these already, where you can see masses of people fleeing just by tracking their mobile phones. Not the individual phone numbers, but just a massive amount of moving, so phones moving from cell tower to cell tower. The UN is now even tracking people fleeing particular attacks through those cell tower analysis. But there is even more. They're starting to develop now analysis that would show leadership positions within a telephone communication network. Obviously, locations of individuals, frequencies of calls. If you call someone 20 times a day, that means you have a much closer command relationship than if you call someone once every 6 months, for example. So there is a science now, and there's a lot of universities who are working on this, where they're trying to develop these algorithms or statistics that show content, that show substance without having a substance. So that's a big thing, but for that I think the future is to use the national jurisdictions, and I don't know in how far the national analysis. There are some countries, national countries, who have a very important analysis capacity because they're doing terrorist cases and because they're doing a lot of telephone tapping or whatever, which is a capacity we don't have. So their cooperation would be key. And I think that now I'll have to stop. I don't know if I had anything else, actually. Belgium, but that has been addressed by ARC. So.
Thank you very much, Olivia, for sharing the successes and the challenges faced by the Office of the Prosecutor. And we will now have the presentation of our next speaker, Catherine Denis. So Catherine is a lawyer specialized in international criminal law and transitional justice. She represented victims in 2 cases before the International Criminal Court between 2009 and 2015. And before, she was a legal officer in the International Criminal Tribunal for Rwanda. And Catherine, you have the floor.
Thank you very much. And for sure, I'd like to join the voices of the other co-panelists to thank again for organizing such an event. I think it's important to look back at what happened 20 years ago, what happened now, what are the lessons learned, what are the challenges ahead. And today I'm very happy to talk about what is actually one of the key components of the ICC, what I call the DNA of the ICC in a sense, victims' participation. And I'm going to talk about this from a very personal point of view, maybe subjective, but at least it will hopefully give some practical view of the matter. And my first point is probably to look back a bit about history in terms of victims' participation. Before the adoption of the ICC statute, victims were mainly confined to a role of witnesses during the proceedings. So before the ICTY, we mentioned earlier the Yugoslav Tribunal, and the ICTR, the Tribunal for Rwanda. This was mainly due to the fact that those statutes were drafted under the influence, sorry to use such a word, but the influence of common law and common law legal officers. So it was drafted in that context. And the result of that is that the contribution of victims during trial proceedings were narrowed down to accounting certain facts to serve the case of one of the calling parties, most of the time the prosecutor. But the problem with such a situation is that the victim is called to testify on very specific facts, which sometimes, in the view of the victim, does not necessarily reflect the entire picture of what the victim has suffered at the time, and therefore may also cause some form of re-traumatization. And this position of victims before the ICTY and ICTR was one of the criticisms towards those tribunals at the time of the discussion for setting up a permanent court. Thus, during the discussion, the preparatory work on the ICC statute, there were some attempts to try to include victims' participation in such a document. But in fact, it's really during the negotiation in Rome, so 20 years from now, that there had been a major progress in having actual words and actual provisions in the statute dealing with the participation of victims, but also reparation for victims. And in that respect, it should be mentioned that Belgium, which was part of a group of states, which was called, if I remember well, the like-minded states during the negotiation in Rome, Belgium was one of the key actors in bolstering this agenda to have victims explicitly mentioned in the ICC statute. And what it should be also noticed about the history of this inclusion of victims' participation is the fact that there were also two visions. It's a bit a simplified version of the history, but if we put it in a nutshell, there were two visions also of this issue. One, again, very much common law, not familiar that much with victims' participation, and very much more working on a basis of protecting at the utmost the rights of the accused persons. And then the opposite side, which is civil law vision, with the possibility for victims to participate to proceedings and in certain systems even to trigger prosecution and investigation. And why do I mention this? Well, simply to explain a little bit what is the applicable law before the ICC as a result of this negotiation. And this is my second point. When you open the ICC statute and you look for participation of victim and reparation, you will see that actually there are 3 paragraphs in 3 different articles dealing with participation of victim, and there is 1 article dealing with reparation. So this is really, for me, it's clear, it's the result of this compromise. And the result of having such cryptic article provisions in the ICC statute is also that the case law of the ICC has been instrumental and is still very much instrumental in defining the exact scope of the victim's participation before the court. And it also implies some form of uncertainty as to the rights of victims before the court, because a trial chamber may take a decision that can be overturned by the appeals chamber, and except the appeals chamber is supposed to maintain the case law, but you can still expect that one day, maybe, an appeals chamber will turn down some prior case law. So what are, in a nutshell, the possibilities for victims to participate before the ICC? First, at the investigation stage, and provided that it is triggered by the prosecutor, as it has been explained, there are three ways, and one way is the prosecutor to trigger investigation. In that case, victims may file submission with the pretrial chamber. Victims may also submit observation in terms of jurisdiction of the court or on the admissibility of a case, but again, provided that the prosecutor has raised this issue before the pretrial chamber. Then the most important part is the victim's participation at the trial stage. It's Article 68 of the statute, and I will come back to that. And then last but not least is the reparation phase for the victims, provided that the person is convicted. There is no reparation if there is no conviction. And it was mentioned before, the particularity of this is also that victims are considered as participants to the proceedings and not parties, and it makes a lot of a difference, except for the reparation phase where they become actually a full party, if I may say. Article 68, as I said, is really the heart of the victim's participation before the court during the trial proceedings. And if you read that paragraph, and I apologize, I'm the only one not having a PowerPoint, but victims, we never have enough money actually to represent our clients, so that's the reason why. So Article 68 imposes, I would say, two sets of requirements and a number of modalities when you read. The first requirement is that the victims must show, to participate, that their personal interests are affected. That makes sense, for sure. But it goes to the point that when you are during the trial, when you want to submit an appeal before the appeals chamber, you have to show each time that the victims have indeed a personal interest to challenge or to discuss the issue before the appeals chamber. And it has an impact on the length of proceedings, because for sure your submission is longer and the appeals chamber has to look into that first. Second requirement is that the victim's participation cannot cause prejudice or be inconsistent with the rights of the accused or a fair and impartial trial. Makes sense as well to have this balance, but it's a difficult exercise. Then in terms of modalities, still under Article 68 of the ICC statute, you will see that victims' participation is translated by the following words. The victims may present, I quote, views and concerns. And from there, you have all the victims' participation before the ICC. What does it mean? And this has been the development under the ICC case law. And I'll come back to that because I just want to also insist on the fact that in terms of modalities, they may present views and concerns, but at each stage of the proceeding, whether you are before the pretrial chamber, the trial chamber, or the appeals chamber, these modalities may change. What I mean by that is that the pretrial judge will determine how the victims may participate in the proceedings. This decision applies at the pretrial phase. Whoops, you move to the trial proceedings, new decision. You move to the appeal, new decision. So each time, you're never sure whether the modalities granted before will keep on applying after. It was very much true at the beginning of the functioning of the ICC. And the third modality, which is important to mention, is that, and it's the practice at the court, is that those views and concerns are in fact presented by the so-called legal representative, which is a counsel, actually. So victims are not, it's not the practice to have victims in the courtrooms and presenting their views and concerns. Views and concerns, what does it mean in the practice of the court? a number of things, but I thought it would be interesting to highlight what were the first elements decided by the appeals chamber. The very first element granted by the appeals chamber is that the counsel for victims were authorized to sit in the courtroom. So you are representing clients, because that's the relationship you have with the victims. They are recognized in the ICC statute as participants. Well, there was need to have an appeals chamber decision to say that as a lawyer, you may indeed sit in the courtroom and not in the public gallery, which is quite different. And the counsel is also authorized to sit in closed session. Sometimes you have victims testifying, and therefore in that situation, because you need to protect the anonymity of the victim, there might be private sessions, and the counsel was allowed to sit in the courtroom at the time. The counsel are also granted access to the record of the file. Again, for me, as a counsel, it's very strange, because how to represent a person if you don't have access to record of the file? But the appeals chamber had made clear that it is granted. Counsel may make opening and closing statements, and they have the possibility to examine witnesses from prosecution and defense under strict control of the court. They may also call victims to testify, and that is probably one of the most interesting parts, but again, under very strict control of the chamber. The victims may also suggest the chamber to call witnesses, other witnesses. They may make oral and written submissions. So that is really, in a nutshell, what you will find as the core elements as of today in the case law in terms of what does mean views and concern, but depending from a case to another, those modalities may expand for a number of reasons, but those are the basics. Now, I'd like to move to my two last points, which are some lessons learned, and I do not pretend to have a comprehensive list of lessons learned, and also what I would like to say, looking to the future. Some lessons learned, well, I think, and I'm happy to have here a representative of the prosecutor who was involved in the very first case before the court. I think in the very first year, there were lots of challenges against victims' participation. If I may summarize, they were like a bit the undesired participant in the room. The presence was not desired in the room. And there were a number of reasons that I think we can reasonably understand. Part of these reasons are the fact that judges, prosecutors, defense were mainly from common law tradition. And there was really a worry, a concern to have these victims in the courtroom acting as a prosecutor base, as a second prosecutor. So it was not easy for the judges particularly, but also for the prosecutor and the defense, to see how the balance between fair trial and rights of the accused could be guaranteed with the presence of victims in the courtroom. And, well, how did it work actually? What was a key success factor, in my view, in victims' participation? And again, this is my very personal experience. It has been to build trust. To build trust first with the victims, because actually you are in The Hague, but victims are, in my case, they were in DRC, in Congo. So you have to build up a channel of communication with them, build confidence on the fact that you're going to explain to them what's going to happen in the courtroom, in the proceedings, and that you're going to convey their voice to the court. But also build confidence with the judges, the parties and the registry, and I can tell you, well, the judge in this case said explicitly on numerous occasions that he had found that the contribution of victims was instrumental. But we had also to build a good relationship with the prosecutor, sometimes looking at us like a bit, they might be dangerous, and the defense not happy at all to have probably a second prosecutor. And in that respect, I should highlight that victims have have different expectations and concerns from the prosecutor, and it's quite natural. The prosecutor has a certain mandate, and the victims, they are representing their own interest. And a very concrete example is again, in the case I was working, is that victims are looking very much for the truth, in the meaning that they want to understand what happened, why it happened, how it could happen, what are the structures responsible for what happened. So in that case, for instance, one of the accused person was acquitted at the end of the day, and the victims were frustrated not so much by the fact that he was acquitted, but by the fact that were left without answer about part of the history, about who was responsible. And also the second aspect I like to highlight is that victims play a complementary role to that of the prosecution. Often an issue in conducting case before the court is an issue of time and an issue of possibility to contextualize a case. And as it was said before, it's not easy each time there is a new context, a new case, to offer this contextualization. And again, victims' participation allows for that, allows for this complementary information to put a wider picture and maybe to put a little bit humanity in some of the discussions. For instance, again, a very concrete example. In that case, it was about an attack against one village on one day, in which they were very much pillaging of herds of cows. And for sure, the prosecutor presented that in the submission, but for the victim, it was not only pillaging an economic consequence, it was more than that, because in these communities, having a lot of cows is a symbol of social status. It's also the savings. It's like you've been robbed everything you had at the bank. It's the same thing for them. So it had major consequences on the economic status of the person, but also on the psychological level. And because of the participation of victims, we were able to show this picture to the judges through the testimonies and also through the concluding arguments. And I like to finish about lesson learned with, yes, victims' participation makes a big difference, because it moves a perpetrator-oriented justice, which was very much the case with ICTY and ICTR, to a picture where victims is more at the center. And we had here the ambassador of Netherlands mentioning reconciliation. And indeed, this is part of the deal. Having a victim-centered approach increase the possibilities to move towards some form of reconciliation. So participation of victims allows some form of reparative justice and hopefully transformative justice. And for that, I like also to give an example very concretely, again, in this case. In this case, the facts were committed in 2003. And discussions on reparation are happening now in 2018. Well, started last year, 2017, but actually the final decision is about now, 15 years later. And the issue is, okay, at the time, someone had a house in the village, the house was destroyed. So normally, you would apply that the person should receive a new house in the village. But if the person has left the village, is living abroad, is the reparation really to provide a new house? What about the father who had many cows and they were pillaged and he's no longer in a position to offer school to his children? Well, maybe that's what he would like to have as a reparation today, not 100 cows, but to offer schooling for his children. And that was the argument moved by us in the case to the Chamber, and the Chamber took these arguments on board to take into consideration the current situation of the victims and what would make more sense in terms of reparation as of today. That's why I like to talk about reparative but also hopefully transformative justice. And then my last point, looking to the future, and again I like to focus on key elements, I'll be very concise. Well, there are still many challenges. Let's be honest about that, and I do not certainly pretend to have answers, but we must frankly look at them and try to find answers, whether within the court, with the different organs, or also from member states' perspective. Challenges include, I would say, the issue of access to justice. Because of the nature of those crimes, a large number of victims are affected by them and potentially may be participant to the proceedings. And this is an issue. How to having them effectively participating to the proceedings? What's the cost? What's the impact on the length of the proceedings? It also raises an issue of understanding what is justice, understanding what is the role of the ICC in that respect. It also comes to managing expectations, and in that I include reparations. Let's face it, those crimes are committed in poor countries. Some of them are purely looking for monetary reparation. Not all of them, but some of them. And this is an issue. Avoiding re-victimization also. When you have a trial starting in 2009 with potential promises of reparation, ending now, more than 9 years later, where they're discussing reparation, that maybe they will get reparation starting as of next year. It's a long time to wait. It causes also issue of, because these victims, we've met them several times and we discuss what they have suffered, we discuss what they would like as reparation. It's a difficult exercise to avoid re-victimization. Then how to afford reparation? We mentioned the issue of accused persons who are indigent, who claim to be indigent as well. And this is also an issue to be solved, to be looked at. And in that context, we can query the role of the trust fund, humanitarian assistance versus providing reparation for delivering justice. And then my last comments about potential solution, in my humble view, dealing with the issue of victims' participation and reparation from the beginning of a case. So far, it's not the approach. The approach is to say, well, if there is no conviction, there is no reparation, so there is no point really to discuss this. And I think it's a wrong approach, because it could be a way to manage expectation and also to have different ways of participation of victims to a trial. And in that aspect, the role of a counsel is key, because as in any system, a counsel has a role to advise the client, and sometimes to advise the client not to go to a trial, not to participate to a trial. Let's be honest. Then I also trust that judges and prosecutors play a key role, and particularly the judges. And here I like to highlight the issue of competent and experienced judges. And I'm very happy to see that over the last years, some states have promoted a better selection of the judges. And also the role of the judges and maybe the prosecutor, but mainly the judges, in reviewing the current practice at the court in terms of the case law. How to improve victims' participation throughout a better case law. And in that aspect, I trust that NGOs, civil society have also a play to role. And last but not least, I trust there is a role for states. And I'm confident that Belgium is going to maintain its support, not only at the ASP, at the Assembly of States Parties, but also to keep on maintaining this agenda. It was said by other panelists, it was said also by the representative of the prosecutor. I mean, yes, there are challenges against the ICC. The ICC is not offering a golden result, but we need to keep on maintaining this on the agenda for promoting reconciliation. Thank you.
Thank you very much, Catherine, for sharing your experience, explaining the improvement brought by the ICC to the representation of victims who have been, as you said in the past, the forgotten actor of international criminal justice. And so now we give the floor to our last panelist for today, Antoine Mison. Antoine Mison is a Belgian diplomat. He was until July 2016 the legal advisor of the permanent representation of Belgium to the United Nations. He was, among others, in charge of the issue of fight against impunity, and his posting as a diplomat, the first posting of Antoine as a diplomat was in Warsaw, so he's a little bit back home. So Antoine, you have the floor.
Thank you very much, Anne-Sophie, and it's good to be back to Poland. Thank you very much for organizing this event and letting us the possibility to say a few words about the fight against impunity. And it's indeed a fantastic setting to do that. And so we thank very much the College of Europe for its hospitality. I'd like to run a short video to begin with.
It was a time when there was still war in ex-Yugoslavia, vicious conflict. ongoing. And there were so many atrocities that the United Nations couldn't stand by and look and ignore what was happening.
We have the parties, please.
"24 years is a long time. So we've done our best. In 1993, no one believed that we would have been able to bring to justice anyone. We have proved exactly the opposite.
Today we are closing with no fugitive at large, with no investigation ongoing. I think we exceeded expectation.
Thank you. That video was made for the closing of the International Criminal for the ex-Yugoslavia, the ICTY, and it followed the closing a few years before of the ICTR for Rwanda. And I haven't played that because I'm lazy. Well, partially might be that, but it's also the fact that it shows us the potential of the UN as a tool to fight impunity. And Belgium has made a priority of the fight against impunity, and so we are trying through the UN to do our utmost to uphold that priority. So during this presentation, I'll try to make a quick overview of Belgian actions at the UN, and I will dwell a little longer in 6 months of UN, Belgium, but also others, diplomacy, which was the process that led to the creation of the IIIM, the International Independent Impartial Mechanism for Syria. So these are the different actions I would like to speak about with you. Most of them I took part in, so I'm quite happy to be able to provide some insight. The first one I was not, because the MICT, so the UN International Residual Mechanism for the criminal tribunals, was in fact, the resolution for this adoption was adopted in 2010, but Belgium was, I think, instrumental in its creation, and I think that Catherine, for instance, was very much involved in that process, starting from 2008 with the Belgian presidency of an informal working group that worked on that working group of the Security Council. And that's, for instance, one of the settings of the 15 lawyers of the members of the Security Council that we will be able to work with starting from January with Poland, that will still be at the table of the Security Council at that moment. Another important moment for Belgian diplomacy was the creation, or we have tried to create an international tribunal for the downing of the MH17 flight. You might remember that on 17 July 2014, a KLM flight starting from Amsterdam and going to Kuala Lumpur in Malaysia was shut down over eastern Ukraine, a region that was held by, that is still held by Ukrainian rebels, pro-Russian Ukrainian rebels. 283 people, passengers died, alongside 15 crew members. And these are the first pages of some of the British journals that appeared the day afterward. And among which there were 200 Dutch citizens. So the Netherlands directed first a technical investigation into the downing of the flight, the Dutch Safety Board, but alongside the technical investigation, you had a criminal investigation that tried to see who were the person behind that and how could you prove that they were behind it. And a joint investigation team composed with investigators and prosecutors from 5 countries directed the investigation. So we had people from the Netherlands, from Belgium, from Malaysia, from Australia, and also from Ukraine, over which territory the downing of the flight happened. At some point, when you have a case, you have to foresee which jurisdiction will handle that. And here it was particularly difficult because several countries were involved, and it was the wish of the Netherlands to have an international tribunal judge that. And so what we try to do is to create that tribunal under the Charter 5 of the Charter of the United Nations, which makes, in fact, cooperation with that tribunal compulsory for the different countries. So that was the purpose of the exercise. It was a complex endeavor, also because we were first negotiating the statute of this tribunal among the 5 countries, and I took part in that with my colleague from the different countries, different legal culture. So we had to find a way to gather and to create something that made sense. We managed to do that through friendship and a lot of Malaysian food at the Mission of Malaysia. That helped very much. But, and then it was a very hard exercise of outreach toward the Security Council members that speak politics, and it's quite interesting to see that from the inside. But unfortunately, and we were prepared to that, it did not work out because we faced a veto from Russia. And that's the press conference just after the veto from Russia. That's the Minister for Foreign Affairs of the Netherlands, surrounded by his colleagues, and the Ambassador of Belgium on the left hand, Ambassador Franquinet. Okay, we also worked on the Special Criminal Court in Central African Republic. Mainly it was about giving political support to the idea of this court and to the setting of the court, but we also try to give some of our experience, for instance, in negotiating the agreement to lend national magistrate to the court. So we had talks with the UN on that. We also tried to send a magistrate. There was a decision of the Belgian government to do so. We had several candidates, but unfortunately it did not turn out like we wanted to do. But we were very much committed for that. For instance, we held working lunches in New York. That's the meeting room of the Belgian representation in New York, the 41st floor, the windows giving a view on the Hudson River. Security Council is a few steps from there. And you see Fatou Bensouda from the ICC, prosecutor of the ICC, Ambassador Franquinet, and Ambassador from Luxembourg, and Ambassador Venavezer from Liechtenstein, together with the Ambassador from the Central African Republic. So we did a lot of that, mainstreaming the idea in a lot of speeches and so forth and so on. So we were also very much involved in the nitty-gritty of the ICC. The ICC bureau, we were in the bureau in 2013, 2014. I had the pleasure to sit with my Polish colleague. There we had very nice cooperation with all the members and with Poland. Here it's one of the mainstreaming events, I would say, about the ICC in New York. It's the accession of El Salvador becoming a state party to the Rome Statute. So not only bad news about the ICC, but in 2016 we had our last member of the ICC. That was a great moment, and I think it's the Prime Minister of El Salvador, together with Ambassador Cardi, Deputy President of the Assembly of State Party to the Rome Statute. The crime of aggression, I could speak 1 week about that. That's a very heated topic in New York. Maybe you have not heard of it, but that was one of the main topics in New York for the past 2 years. Many meetings, many explanations about that. Basically, it boils down to the fact that it's about the crime against peace we have heard of during the Nuremberg trials and the Tokyo trials. 4 crimes in the Rome Statute. We've got crime of genocide, crimes against humanity, war crimes, and the crime of aggression. But the crime of aggression was not defined during the negotiation of the Rome Statute because it was politically difficult to find an agreement back then. But we had just the line, the crime of aggression. It gave the way to what we called the Princeton process, with a lot of discussion at the Princeton University, led by Liechtenstein once again. And it was a little miracle in 2010, we agreed on a definition in Kampala. But we did not activate the competence of the court, the jurisdiction of the court of the crime of aggression. That was left for later. And later, that was last year in December in New York, where we had the activation decision for the crime of aggression. So now the court is competent to judge over that. I will not enter into the details, but Belgium was part of what we called the protective camp that wanted an as broad as possible activation of the jurisdiction of the court. Unfortunately, it did not turn our way because we have a much smaller activation of the crime, of the jurisdiction of the court. Anyway, yeah, that was the night of the 14th December 2017. It finished at 2 o'clock in the morning. Delegates were wandering here. Okay, sorry. Maybe I should stay here. Okay, I'll do that. I just stay a little closer to the mic. Okay, war crimes amendments. Belgium was very committed to the Rome Statute. That was something that we already discussed in Rome, that we tabled in 2009. And that was a lot of my work in New York, 3 years of outreach, 3 years of... I spent, I think, over 50 coffee meetings in the Pain Quotidien in New York. I'm sure that they bankrupted after I left. Anyway, convincing people one by one that we had to adopt these amendments, criminalizing the use of biological toxin weapons, anti-personnel mines, weapons injuring by fragment non-detectable through X-ray, and weapons causing permanent blindness. It was a huge diplomatic effort for Belgium. Really, you cannot imagine the number of meetings of people that were involved just in that, just to have that in the Rome Statute. But I must say that we receive a lot of support from the political level. For instance, our Prime Minister raised the topic during his speech at the General Assembly in 2017. Our Minister for Foreign Affairs, Deputy Prime Minister, spoke to a number of persons about that. Our Minister for Justice was the head of delegation in December to defend the ID. So really, we received a lot of support, and that was very nice to work with that. Here is one of the meetings in 2017 of the working group on amendments, where we discussed that in New York, and I'm trying to convince my colleagues of that. We had several of these meetings. The ambassador, deputy ambassador of Norway there with her legal advisor, very nice people. And that was in December 2017. This ambassador is Yves Azendonk, who was, the active head of delegation, I would say, of Belgium. And there he opened the first meeting of the WGA. At the end of the first week, that was a tremendously difficult week for us, because we met with a lot of the opponents to the amendments. But at that meeting, the things turned, because we received the fruits of our work with a tremendous support from over 35 countries in the room, which is a lot. And I must say that Poland was the first to take the floor and to support and announce her co-sponsorship of the amendments that helped us tremendously. Yeah. And yeah, I'm here answering the technical questions during the WGA meeting. That's the team, and that's the tweet of the minister once we agreed on the adoption. That was good for us all, I'd say. Okay. Yeah, the MLA initiative, someone has mentioned that, I think it was Wenke. Yeah, that's indeed a very important endeavor. Next year we will have the second PrepCom meeting over the draft treaty, and the purpose is to get a framework for judicial authorities to cooperate among themselves for national prosecution of the most serious crimes. The investigative team in Iraq, we took part in that as well, mostly in raising awareness about what the Yazidi and others were suffering in Iraq and also in Syria. And we organized a side event during the Ministerial Week in 2016 with Nadia Murad, with now a Nobel Prize, and a lawyer, Amal Clooney, and a couple of others. And I'd like to delve a little bit more into what was a very interesting process, the International Impartial and Independent Mechanism for Syria, the Triple IM. Could you run the video? Thank you.
After more than 3 years of bloodshed, this was the chance for the Security Council to refer all the crimes committed in Syria to the International Criminal Court. 13 countries, a large majority, were in favour, but it will not happen. Only 2 states voted against, but Russia and China are permanent members of the Security Council. This is the 4th time they've used their veto on a resolution related to Syria.
Today is about accountability for crimes so extensive, so deadly, that they have few equals in modern history. Sadly, because of the decision by the Russian Federation to back the Syrian regime no matter what it does, the Syrian people will not see justice today. They will see crime, but not punishment.
The Russian ambassador made it clear he felt the French, who drafted the vetoed resolution, were looking for something more than justice.
Is this just to try once again to create a pretext for armed intervention in the Syrian conflict?
France's ambassador, whose resolution had been co-sponsored by more than 60 nations, told me after the vote this had been a sad day.
What's your message to the people of Syria?
No, I think I really am ashamed, really in a sense, to tell them, we are sorry. My country, France, has tried its best, but France can't act alone, really, that's a fact, really, and which means that in the coming weeks and months there will be more dead, more devastation, more rapes, torture. It's really awful.
Al Jazeera has obtained a copy of a new report from the UN Secretary-General to the Security Council about humanitarian access in Syria. It's grim reading. It suggests the situation is getting worse. Some countries now want a new resolution to try and get further humanitarian access, particularly across borders, without the Syrian government's permission. The problem is such a resolution could again face a veto. James Bayes, Al Jazeera, of the United Nations.
Thank you very much. Oh. Okay. Okay. Yeah, try to. I'll do that, okay? Here we go. The war in Syria, terrible facts. You see that there. You have to realize that Syria in 2011 was a country of around 20 million people. So when you speak of 5 million people seeking refuge abroad, you have an idea of what it represents. 6 million internally displaced, 500 million besieged. And these figures do not even render what the people were facing there. And that became very clear in 2014, for instance, with the CISA report. So a military from the Syrian regime was tasked with documenting what happened in the prison, defected with over 50,000 pictures. And these pictures were assessed by a team of prosecutors that found that they were proof for the killing and the torture of over 11,000 people in just one prison, which means that that happened in other prisons, and there was certainly a systematic organization for killing and torturing people. I will not describe what were in these pictures, but it's quite horrendous. And the prosecutor was sure that it could amount to war crimes, crimes against humanity. So what do you do with that, given the situation? The first thing you think of is the ICC, but you have seen a little earlier on that it's very difficult for the ICC to have jurisdiction over Syria. Syria is not a state party. It's highly improbable that Syria will accept the jurisdiction of the court, and so the only solution is for the United Nations Security Council to refer the situation to the ICC prosecutor. But we have seen what happened with this video from the French resolution. The French tried to refer the situation to the ICC. It was vetoed by Russia. So, do you sit and cry? You could do that, but it would be good to find a way to kind of bypass this dreadlock at the Security Council. And this is what we try with a group of countries, led by Liechtenstein, by Qatar. We had also neighboring countries, Saudi Arabia, Turkey, and a few others, Jordan, because you need this political support to go along and to go a little further. But also countries that were the most active in the fight against impunity. We had Denmark, we had Sweden, we had Canada, we had Belgium, we had the Netherlands, and Liechtenstein, of course. And so we were reflecting how can we take action to bring some measure of accountability despite of the dreadlock in the Security Council. And so we reflected already in June. We had non-papers, and this evolved over time. And we were thinking of action by the General Assembly of the United Nations, accountability resolution that would give some visibility to the topic. We also thought of requesting an opinion, advisory opinion from the ICJ, maybe on the model of the Isenabre case. We had some blueprint there, etc., etc. Action by the Security Council was almost off the table. The International Court of Justice directly, Truth Commission, prosecution by national jurisdiction. We knew that in France, in Germany, and in Norway we had some national cases concerning Syria, so that could be an ally. But the turning point for us was when we met three NGOs that were collecting data and collecting evidence. They had a very huge number of evidence, but they did not have analysis on this evidence. They did not have any compiled file that we could use in front of a criminal tribunal. So came up the idea of creating what was first called an accountability center and then an accountability mechanism, and that became the IIIM. The purpose was to create a mechanism that would gather the evidence that were already there, collected by NGOs, but also by a fact-finding mission that were already commissioned by the different organs from the UN, for instance, and to analyze them and to create almost ready for use files that could be used by different tribunals, be it international tribunals like the ICC one day, or be it national tribunals or other, let's say, hybrid tribunals that could be created later on. So this is what we try to do. Meanwhile, the situation was getting worse with bombing of Aleppo. And the Syrian government was impeding any access to relief organizations. That was a real terrible situation. And in October 2016, the Security Council failed to adopt another resolution on Syria due to another Russian veto. And so we had two groups of states working together, one led by Canada for a political resolution for the end of the conflict, having accountability aspects but focusing on relief for the population. And we had this group led by Liechtenstein with Belgium and others thinking of a resolution to create the triple IM. There was also a question of timing because we knew we had to wait for Canada to adopt first its resolution, but we had to have our resolution adopted before the end of the year, because what happens at the end of the year, mission begins to be depopulated, people are going for Christmas leave, and in January we were sure that we would have lost the political momentum, which is very cynical, but it's a very crucial parameter in diplomatic life. Whether you have your public opinion with you, whether there is a sense of we have to do something right now, and this is what was happening. So we had the Canadian resolution adopted, I think, on 9 December, and we had another just before, on the 5th of December, resolution of the Security Council that was vetoed. It was the 6th time that Russia vetoed a resolution on Syria over the 2 past years, the 2nd time in 2 months, and that was a resolution that was aimed at getting the relief going there, but it was vetoed. So that left us less than 10 days to negotiate a resolution and to get the numbers, because these resolutions are not consensual. Our amendments were consensually adopted by the Assembly of the State Party. This one we were sure that it would be contentious and that we had to get the numbers. There are 193 member states of the United Nations. You have to get a majority of the present and voting, but some country opponents can trigger a 2/3 majority requirement. And so we also aimed at 100 vote in favor, because it was politically what we wanted to have. The Canadian had over 120. They had 1 month to do their outreach. We had something like 8 days, which is very short. But somehow, through a lot of meetings, and I must say that once again, my government was very instrumental, because Liechtenstein was very active, but they had 2 representations, one in Brussels, one in New York. How do you do the necessary démarche all over the world, because this is what is required to get this adopted. So Belgium has the chance of having a very broad diplomatic network with over 100 diplomatic representation everywhere, and we send instructions to all of our ambassadors to go to their Ministry for Foreign Affairs where they were accredited to get the vote and possibly the co-sponsor of that country. And I'm very proud to say that that's an exercise that we fulfilled with success. So we were also very much involved in New York. There were very, very long days, a lot of meetings, mails during weekend, during the night. That was a very hectic moment, but a very fulfilling one, I'd say. Okay, at the end of the day, we got 58 co-sponsors, which is extremely high. We hunted the representative of the different delegation in the different rooms of the United Nations. When we knew that their capital was in favor, we really hunted them with the list of co-sponsors. You have to sign there. This is your minister telling that you have to do so, and yeah, that was kind of the thing that we had to do to get that. I must also say that Belgium was the country that convinced the US to get on board of this resolution, because the situation was quite heated between the mission of Liechtenstein and of US over a specific technical point. And somehow, thanks to the Belgian cake that we ate at the Belgian mission maybe a little later on, we managed to have an agreement in the night before the vote. And so during the night, US activated its own network of embassies to get the last votes and the last sponsor that we needed to get to have the resolution adopted. This is Ambassador Venavese from Liechtenstein presenting the resolution at the UN General Assembly, and these are the results of the vote. 105 votes in favor, 15 no, you can guess who were the no's, and 52 abstention. So we created something, not only Belgium, of course, but we created something that I think makes a turning point in the fight against impunity, because we had a dreadlock. With that, we push a lot of pressure on the Security Council to act, because they lose faith with that. And it's also an embryo of Office of the Prosecutor. Now it's in full functioning, it's totally operational. It's led by very, very competent persons. It's acting under the radar, and it's compiling dossiers that could be used one day, maybe by the ICC or maybe by other tribunals. And so people in Syria know that there is a possibility that one day they will be held into account. And so I think that's a great achievement of the UN. Thank you very much.
Thank you very much, Antoine, for presenting all Belgian diplomatic efforts in the field of the fight against impunity. Unless there are urgent questions, I would suggest that we continue the discussion during the lunch. But before letting you go, I would like to warmly thank once again all our panelists on behalf of Luc Jacobs, the ambassador of Belgium in Poland. And I have a little present for you all. And so we invite you now to the lunch that will take place in the Natolin Palace. And thank you, all of you, for coming today.